Today we're going to talk about HIPAA. HIPAA stands for Health Insurance Portability and Accountability Act. It's important for both patients and doctors every day. Patients want to make sure their information is kept secure, and doctors do not want to violate HIPAA regulations. There are several important definitions you'll need to know before I start my presentation. The first is PHI. This stands for Protected Health Information. It's anything that can be used to identify an individual, such as treatment, diagnosis, date of birth, name, address, etc. Second is ePHI. This is a relatively new term that stands for Electronic PHI. It's essentially anything that's contained in our IntelliPath system. A covered entity is any clinical organization, such as a medical practice, clearinghouses, or pharmacies. The workforce is what all of we are, employees or volunteers of a medical provider. Uses and disclosures are common terms used interchangeably, but they have different definitions. A disclosure is the act of distributing PHI from a covered entity to a third party. An example of this would be if someone from our office was talking to someone from Arizona Skincare Physicians about a patient. A use is the act of distributing PHI internally within a covered entity. An example of this would be two coworkers at our office discussing a patient. A business associate is anyone that creates PHI or has access to PHI on behalf of the covered entity. An example of this would be the courier service or the tech people that work on our computers. There are three main rules to HIPAA. The first is the privacy rule. This is a component of HIPAA that most affects our daily lives and what most people think of when they think of HIPAA. It's about keeping patient information secure and private. The security rule is about protecting ePHI and who has access to specific PHI. The third is breach notification rule. It is required by law that any medical practice or business associate notifies an individual if their information has been viewed when they do not want it to be. The fundamental rule of the privacy rule is a covered entity may not use or disclose protected health information except as permitted or required by the privacy rule or by the enforcement and compliance provisions of the HIPAA Administrative Simplification Rules. In short, this means don't give out PHI freely. Do not give out information if you don't think you should be. Privacy rule and what it entails. Uses and disclosures must be authorized by individuals. This is, for example, when you go into a medical practice, you always sign paperwork before you get your treatment. It has to be authorized by the patients for most of their information to be released. Individuals must have the opportunity to agree or object to certain uses and disclosures. This would be, for example, a facility directory or giving information to the family. In general, it is not okay to release PHI to family members or friends. You must have the authorization before. Uses and disclosures by business associates. In the past, business associates have not been kept legally liable for any disclosures of PHI. Now, thanks to a new law called HITECH, they're directly liable for any information they give out. Permitted uses and disclosures for public policy purposes. These are certain times and incidents when it is okay to release and disclose PHI without the patient's authorization. An example of this would be a victim of child abuse or domestic abuse, or if certain diseases have to be reported to the CDC. The rights of the patients. Patients, of course, have rights. They have the right to see their PHI if they ever request to do so. They also have the right to see an accounting of disclosures, thanks to the new law, HITECH. This means that patients have the right to see when whoever accesses their medical file. So for us, IntelliPath records every single person who looks into a patient's file. If a patient is worried about their privacy, they can request us to show them every single person's name that has looked at their medical file. There are required safeguards in the privacy rule. This reduces the risk of accidental disclosure. and would include things such as locks on cabinets, passwords on computers, etc. There's also mitigation of harmful effect of unpermitted uses and disclosures. Pretty much doctors and the medical practice will have to deal with the consequences of releasing PHI. There are specific times when patients do not need to authorize the release of their PHI. Examples of these would be judicial proceedings. If someone is in trouble with the law, then they do not need to authorize the release of their PHI. It can be given to the courts. If a patient is a victim of abuse or neglect, they also don't need their authorization to report it to the police. In order to avoid serious threats to health or safety, many of you have probably heard of a time where a psychiatrist has heard a patient say they want to kill someone. In order to avoid the serious threat or health or safety, the patient does not need to authorize the release of this information. Consultations. This is a big one for us. Doctors do not have to have patients' authorization to consult with another physician. They can speak freely among themselves about treatment. So when we send slides from our office to somewhere in Utah or California, patients do not need to authorize this consultation. They also do not need authorization when discussing payment, treatment, or healthcare operation. So if we send a patient's information to an insurance company to receive payment, it does not need to be authorized beforehand. Note, it is very important if you recognize a patient to keep it to yourself. If you see someone that you know, a friend or a family member, don't tell everyone else, just keep it to yourself and don't look into their file. The minimum necessary standard rule is pretty much the common sense rule of the privacy rule. Only use the minimum amount of PHI necessary to do your job. This means if you don't need to know their diagnosis and you don't need to know what their further treatment is, don't look into it. Only look at what you need to know. Physicians and other clinicians that collaborate in the patient's care may see PHI and can disclose the information to others in consultations. So physicians and clinicians are pretty much the only people who have access to the whole PHI file. Don't browse patients' files due to curiosity. Only view the patient's file to the extent that is necessary to do your job. For example, a lot of my job is calling patients to collect on bills. I don't need to see what their diagnosis was, their clinical impression, anything. All I need to know is the total amount billed, their phone number, and the medical office they went to. Other than that, I should not be looking at anything else. Other people's jobs require them to look more in depth. For example, a transcriptionist would need to know their clinical impression, the doctor's name, a lot more information than I need to know. They still must only look at the minimum necessary PHI to do their job. It is common that common areas can violate the privacy rule. For example, open computer monitors. So if you have your computer open and you walk away to go to the bathroom, make sure you turn it on sleep mode so that anyone walking by can't see it. Unattended fax machines or printers. If you're printing important information or expecting an important fax, make sure you pick it up right away after you print or receive the fax. Leaving confidential information on answering machines. If you're calling a patient about something to do with their health insurance or issues with their date of birth or something like that, make sure you only leave the minimum necessary amount of information. If a patient does not release you the right to call them and leave them extended voicemails, do not leave the voicemails. Most of the time you can find out if a patient is okay with this by looking at the paperwork attached to the requisition. Papers with PHI left on desks. If you are working on a patient's with a patient's PHI, you have a rec in your hand. Make sure that you turn it over when you go to the bathroom so people walking by can't see it, or put it in a locked cabinet if you're leaving for the day. If you have more questions on the privacy rule, make sure you contact your HIPAA officer. In our case, that is Dr. Bernert. The security rule. There's a national security standard that has 3 parts of it to make sure that everyone's PHI is safe. It's dedicated to protecting ePHI as well as PHI. Health and Human Services developed it in 2003 to keep up with the changing technology of our society. The first standard for security is administrative. These are written procedures that must be put in place by the covered entity. The policies and procedures need to be documented and available to all patients and everyone that works for the practice. In our case, you can find this on our website, Arizona Dermatopathology.com. Physical. This protects from environmental or unwanted intrusions. Examples of this are locks, keys, our key cards to get into the office, backups for computers in case there's a flood or a tornado, anything that protects from physical intrusions. The third is technical. This protects and controls access to ePHI. This would include things such as user IDs and passwords on a computer. It also records records of access to ePHI, like I was talking about earlier with how IntelliPath records every time we look at a patient's file. This would be put into the technical standard for security. Most common violations. The first is administrative. Most of the time this is due to improper training or not being aware that they're violating HIPAA regulations. Also, lack of response and reporting HIPAA violations. If you're unsure if someone has made a HIPAA violation or you're unsure if you're committing a HIPAA violation, make sure to ask someone about it. You don't want to have a violation just for lack of reporting it. The second most common is technical. This would be too many people have access to computers, passwords are shared, etc. And the last is physical. Workstation security, making sure you lock your cabinets when you have PHI in your workstation. If you have more questions on the security rule, again, make sure to ask your HIPAA officer, which is Dr. Berner. Breach notification rule. First, let's define a breach. It is the unauthorized use or disclosure of PHI not permitted by the privacy rule that compromises financial, reputational, or other harm. So, a breach has to cause harm to an individual. For example, if someone came in and they had a condyloma and you happened to know their first cousin and you shared this information with their cousin and said, hey, I heard your cousin has condyloma, that is definitely, without question, reputational harm and could be considered a breach. Also, if it, for example, you leak information about their diagnosis and it gets them fired from a job, that is financial harm. What a breach is not. It is not the use of information by the workforce. So if I'm talking about a patient with someone else that I work with, it's not considered a breach. It's not a breach if the recipient cannot retain the information they have been presented with. For example, if I'm walking down the hallway with a stack of requisitions and somebody else that doesn't work with us walks quickly by, it's not considered a breach if they can't see, if they glance at the recs because they won't be able to retain the information. It's also not a breach if it's a disclosure of limited information. For example, it doesn't use their date of birth or their zip code or their name. This is a gray area and pretty much just don't give out any PHI if you don't need to. The breach notification rule addresses problems of lost, misplaced, and inadvertent disclosures of PHI. So if you lose requisitions or you accidentally give out too much information. Covered entities and business associates must notify an individual of breach. It's very important that you make sure that they're notified or else it's another HIPAA violation. There are increased requirements and penalties for large breaches. There is a notification process that must be followed each time there's a breach. Every time someone's PHI is considered breached, they must be mailed information about the breach. If this affects more than 500 people, so someone hacked into our computer system and got a hold of all of our patients' information, the local media must be alerted because that way it'll make sure that you reach everybody. Also, the Health and Human Services must be notified immediately if it's more than 500 people. If it affects fewer than 500 people, they just need to be notified on an annual basis. So we do keep a log of every time there's a breach, and once a year we'll notify the Health and Human Services of these breaches. Top reasons for the breach. The first is theft. This could be stealing computer information or just stealing requisitions. People do want to steal health information because it normally contains their social security number, their health insurance information, pretty much the easiest way to commit identity theft. Second is unauthorized access and disclosure. This would be giving someone that should not have information. For example, if someone doesn't authorize their spouse to have their health information and I gave their spouse all their medical information, that is an unauthorized disclosure of PHI. The third most common is loss of information. This would be if you dropped Rex and lost them in the hallway. The most common forms of media for large breaches are first, laptops. We don't have to worry about this too much because we don't really use them, but it is important to know. Second is paper forms, so that would be losing large stacks of papers or files. And the third is desktop areas. So your workspace, make sure again that the PHI is hidden from plain view so that people can't just look at information as they're passing by. If you have questions on the breach notification rule, make sure to contact your local HIPAA officer. HITECH. This stands for the Health Information Technology for Economic and Clinical Health. It updates and expands HIPAA. HIPAA was founded in 1996, and now this law pretty much updates it with the new technology. It was a part of the 2009 stimulus package, and it strengthens the protection of PHI. Business associates are now directly liable. They can be sued and fined by the government if they violate HIPAA. It comes into effect March 26, 2013, and the compliance date is September 23, 2013. This means that we have to follow it right away, but we have until September to work out any kinks in our system. What has changed? The business associates now have legal obligations. Before, they did not. So now, if a courier lost Rex, they would be directly liable for the loss of PHI. All covered entities have to modify their current privacy notices. Ours is currently up to date with HITECH, but all around the United States, medical practices will now have to reprint all their privacy notices that they've used for the last several years. There are increased penalties for HIPAA violations. In the past, the max was about $25,000. Now the maximum fee is $1,500,000, so it's a big up fee. ePHI must be available to individuals if requested. Now, if a patient calls and they want to see their electronic file of their PHI, we are required by law to give it to them. For us, it's a little harder since we're a laboratory, we don't see the patients. We would have to require them to come in and show their ID or come in with a notarized form saying that it is who they are and that they do want the access to their ePHI or their PHI. Either way, we have to prove it's them. Patients can request providers to not give information about procedures to insurance companies if they paid out of pocket in full. This is a big one. So if a patient got something removed and they don't want their insurance company to know about it, they can just mark "Do not bill insurance, pay in full out of pocket." We are required to not give the information to their insurance companies. As long as they pay, then the insurance company cannot see that. So patients now have the option of either choosing to send it to their insurance company or choosing to hide it from their insurance company. Also, the Attorney General can now sue in federal courts due to HIPAA violations. So now there are civil and criminal offenses for HIPAA violations. That means in extreme violations, you can see jail time as well as fees. There are now 4 tiers of violations. It used to be kind of a one-size-fits-all thing. Now there are 4 separate tiers. The first tier is when the person had no clue that they were in violation and they used reasonable care. They followed everything by the book. There's pretty much no way to prevent the violation, but there still was a violation. In this case, it's still $100 per violation with a maximum of $25,000 per year. Tier 2 is when someone really they did not want to violate HIPAA, but they also weren't trained properly or they just didn't use the proper care that they should have been using. This would normally occur from not being trained properly. In this case, still an accident, but still $1,000 per violation with a maximum of $100,000 per year. Tier 3 is willful neglect but corrected within 30 days. This means someone said, well, I think the HIPAA rules are stupid, I'm not going to follow them, I'm going to leave PHI out wherever I feel like I should. Well, if it's corrected within 30 days, it's $10,000 per violation with a maximum of $250,000 per year. Tier 4 is willful neglect but not corrected within 30 days. So same thing. Well, I think HIPAA's stupid, I'm not going to do it. Well, $50,000 per those violations if it's not corrected, and with a maximum of $1,500,000 per year. These are huge fees. You do not want to be responsible for being the person that gets these giant fees on the practice. Recent lawsuits, just so you know, it does happen. Cigna Insurance had to pay $4.3 million due to failure to supply patients with ePHI, and then after that, they failed to cooperate with the Office of Civil Rights. So now, with high tech, the Office of Civil Rights looks into every HIPAA violation. It's not only insurance companies that are having to pay. Massachusetts General Hospital paid $1 million due to loss of PHI. They're also on a 3-year plan to make sure it does not happen again. Attention to us. Private practices are the most common type of covered entity that is required to take corrective action due to HIPAA violation. This means we are private practice, and we are the most common type that are either violating HIPAA and not knowing it, or just need to take corrective action because we're not careful enough. We do not want to be one of these people. We want to make sure that our practice abides by all HIPAA regulations. It is easy in a private practice to get lazier about the regulations just because we know everybody we work with and we're so comfortable with each other. But we have to make sure that we still follow HIPAA regulations because, like you saw, there are a lot of fees, jail time. You don't want to be responsible for any of those. What we need to do: be fully compliant with HIPAA policies and procedures. Implement safeguards such as user IDs and passwords. Do HIPAA audits. We are performing a HIPAA audit this week. And commit to ongoing training. As all of us know, we have definitely been doing this. If you have questions on high tech, you can ask Dr. Berner. You can also ask me, by the way, for any of these questions, since I have read a lot about HIPAA now. And finally, where you can find our privacy policy. All patients have the right to see our privacy policy. It is located online at www.arizonadermatopathology.com. It's on the lower right hand of the home screen. If patients don't have access to the internet, which can happen a lot for us since we have some elderly patients, we will mail them a copy of the privacy policy if they request to see it. Patients also have the right to complain about us if they don't feel comfortable about our privacy policy. And all the forms, Dr. Bernard has them, so if a patient calls requesting for a complaint form, they will talk to Dr. Bernard about that.